Welcome to the Business Scholarship Podcast, a place for interdisciplinary conversations in the broad world of business research. My name is Andrew Jennings, and it's my pleasure to be your host. If you like what you hear today, please subscribe to the podcast on Apple, Spotify, or wherever you get your podcasts. Plus, leave a rating and let other people know about the show too. And if you have ideas for the show, please let me know. My email address is andrew@andrewkjennings.com, and I look forward to hearing from you. All right, time for the episode. Our guest today is Natalya Shnitser, Associate Professor of Law at Boston College. We'll be discussing her new article, The 401k Conundrum in Corporate Law, which was recently published in the Harvard Business Law Review. I'll add a link to the article in the show notes for the episode. Natalya, welcome to the Business Scholarship Podcast.
Thank you. It's great to be here.
Natalya, in my adult life, and probably starting a bit before, a big trend in the capital markets has been the mutualization, the institutionalization, indexation, all those Asians of the capital markets, moving away from perhaps individual stocks or other securities being held by investors. I wondered if you could maybe introduce that at a high level for the listeners, because it's going to be a really important concept for your paper, and what that might imply for corporate governance in the capital markets today.
As institutional investors like BlackRock, like Vanguard, like State Street have accumulated ever larger stakes in U.S. public companies over the last 2 decades, their behavior as shareholders has come under increasing scrutiny. As they've gathered more and more power, there has been greater interest in their behavior, in how they behave as institutional investors. And a lot of this focus has been particularly targeted at mutual funds. And one traditional narrative in the literature has been that mutual funds have been relatively passive as shareholders and also quite deferential to corporate management. And in trying to explain this pattern of behavior, this deference, one idea that scholars have looked into, one thing that scholars have pointed out, is that the largest fund managers also have business lines that offer services to corporate retirement plan. So what does this look like today? Let's say company Y offers a 401k plan to its employees. To run that plan, company Y needs service providers like trustees and record keepers. And it needs to give employees investment options for their contributions and for the employer match. And there are many choices for service providers and investment options. Among those, for example, there might be Fidelity. Fidelity provides record-keeping services to retirement plans, and Fidelity funds may be included as investment options in the 401k plans. And under what I have termed the retirement business theory, scholars have argued that mutual funds have been deferential to corporate management, at least in part out of fear of losing the corporation's retirement plan business. In other words, fund managers would vote in ways that they thought would please management in order to attract or retain the retirement plan business.
Thank you for that introduction. And with that introduction of the retirement plan theory, I wondered if you could talk a little bit about the literature that already supports or argues for that theory, and perhaps some of your motivations in perhaps revisiting that theory in this paper.
So as it turns out, the retirement business theory, it's cited, it comes up a lot in legal scholarship in law and finance, and in regulatory decision-making as well. And in fact, there is some empirical support for the retirement business theory. But here's the thing. The empirical work that lends support to the retirement business theory uses data that only goes through 2011. In addition, in both the legal and the empirical work, the focus has been on whether or not fund managers are meeting their fiduciary obligations when they cast their votes. And that's, of course, an important question. But in focusing on the fiduciary obligations of asset managers, the existing scholarship has overlooked fiduciary and other legal constraints on the retirement plan side. That is, there's been something of an assumption that, quote unquote, corporate managers control employer-sponsored retirement plans and that they can just snap their fingers and just change the fund lineup or switch record keepers to punish those funds that vote against their preferences. But who actually makes decisions about corporate retirement plans? How are they made? What are the relevant institutional and legal constraints? And that brings me to one of my favorite topics, which is the Employee Retirement Income Security Act of 1974.
One of the reasons I'm really excited to have you on the show, Natalya, is that you combine expertise in corporate law and securities law with an area that may be unfamiliar to a lot of listeners, or some listeners who are familiar with the area, it might be a bit intimidating, which is the ERISA statute that you just mentioned. Now, this is a many splintered statute in many ways, but I wondered if you could talk at a high level about the role this statute plays in retirement plans and the role that it plays in capital markets today.
Well, I would be glad to, because this is a very exciting moment for ERISA, as 2024 marks the 50th anniversary of its passage. ERISA is the federal law that governs private sector retirement plans in the United States. And after 5 decades, private sector defined contribution plans hold something like $10 trillion in assets. So there's a lot of capital in the United States that's regulated by ERISA. And what does ERISA do? First, ERISA imposes mandatory requirements for the administration of employer-sponsored retirement plans. For example, plans must be maintained in writing. They must identify a named fiduciary, their disclosures and reporting requirements, as well as prohibitions on certain transactions with plan insiders. In addition, and this has become increasingly important, the statute includes a broad application of fiduciary obligations on those with discretion or control over the plan. So those who are deemed to be ERISA fiduciaries must make decisions for the retirement plan solely in the interest of plan participants and beneficiaries. And if they breach their fiduciary duties, there is a risk of personal liability for fiduciary and co-fiduciary breach. Now, when might such risk arise in the context of 401k plans? Recent case law has clarified that ERISA fiduciaries bear responsibility for the selection and oversight of investment options and service providers. And the case law piece is particularly important here because ERISA litigation has increased quite dramatically in recent years.
With that, I wondered if you could introduce the process of writing this article. What strategy did you pursue, and how is that strategy aligned to some of your research questions?
So my research questions and strategy in this project reflect my interests in 2 areas of the law: corporate law and employee benefits law. In my prior research, I have used the corporate governance lens to analyze the U.S. retirement system, including the organization and governance of public and private sector retirement plans. In this project, I wanted to bring the employee benefits lens to corporate law. And in bringing the ERISA perspective, I first wanted to shed light on the institutional context and the legal constraints that shape decision-making within retirement plans. And secondly, I wanted to highlight how recent changes in plan governance bear on the retirement business theory and on corporate governance debates more broadly. My empirical strategy was to trace the evolution of 401k, ERISA litigation, and to construct a database of lawsuits involving 401k plan fees and investments. I also combined insights from the litigation records, from plan reports, and from industry surveys to shed light on plan governance. That is, again, who is actually making decisions on behalf of these plans? What does retirement plan governance look like today?
Could you talk about some of your principal findings from this study? In particular, you identify a number of actors and mechanisms within corporate governance that perhaps weren't previously appreciated by scholars. I would love it if you could maybe introduce some of those to the listeners as you introduce them to the literature in this paper.
The first thing I would say is that ERISA 401k plan litigation itself has been an important actor in the story, perhaps a newer actor in the story. As 401k plans have grown in the United States, they have come under more scrutiny by participants, by regulators, by plaintiffs' lawyers. Since 2008, about 1,000 ERISA lawsuits have been brought alleging fiduciary breach in the selection of funds and service providers. Plaintiffs have argued that as a result of such fiduciary breach, participants have been subject to excessive fees, which have diminished their retirement savings. Over this period, the case law, including several Supreme Court cases, has clarified that plan fiduciaries are responsible for selecting prudent investment choices and for monitoring the investment options and managers chosen for the plan. Many S&P 500 companies and their directors and officers have been implicated in this costly and often protracted litigation, which has already generated over $1 billion in class action settlements.
I'd like to delve into that role for litigation in a bit more detail. What is the role for litigation or the threat of litigation in this area? How does that shape decisions by ERISA fiduciaries? And how does that perhaps relate back to the retirement plan theory that you mentioned at the top of the show?
The waves of ERISA litigation have brought about changes in how corporate retirement plans are run. The litigation has led to the formalization of plan governance. For example, retirement plans have set up and expanded committees to make the fiduciary decisions on behalf of the plans. They have staffed these committees increasingly with folks from finance, HR, and legal, while specifically excluding C-suite executives to shield them from some of this ERISA liability. Companies have also formalized the process by which plans select investments, investment managers, and other service providers, requiring, for example, the use of routine RFPs and benchmarking. And finally, the rise of ERISA litigation against plan fiduciaries has driven up demand for and the cost of fiduciary liability insurance. And as a result, fiduciary insurance providers have come to play the role of governance monitors. That is, insurance companies are now keenly aware of the litigation risks and engage in closer examinations of plan governance before issuing fiduciary liability insurance. Together, I would say the changes have imposed additional constraints on management's ability to credibly threaten funds who vote against management preferences. So at present, changing a plan provider or the investment lineups involves some real transaction costs and litigation risk, and it's something participants care about and are affected by.
With these findings in mind, what implications does your paper have for how we understand institutional investors and the capital markets and corporate governance today? And are there any priors that academics writing in law or law and finance or finance might need to update after reading this article?
The institutional changes on the retirement plan side do suggest that some of the traditional explanations of mutual fund voting need to be reevaluated. And in fact, diminished concern about managerial retaliation through the retirement business is consistent with some recent developments, including evidence of increased fund activism and with newer empirical work documenting declines in funds' so-called management bias between 2015 and 2020. While the reasons for growing fund activism are multifaceted and may include both pressure from current investors and competition, future millennial and Gen Z clients, developments on the retirement plan side likely factor into the changing behavior of institutional investors.
What key takeaways would you like listeners to have from this interview or from the paper?
So with over $10 trillion in assets, employer-sponsored defined contribution retirement plans play an important role in the corporate governance ecosystem. I would suggest that a better understanding of retirement plan governance, a deeper understanding of retirement plan governance, and the way that it has changed in recent years informs important ideas in corporate law, particularly at a time when pension funds are at the forefront of debates about ESG, pass-through voting, and human capital management more broadly. Based on my findings in this paper, ongoing data collection and analysis is needed to analyze current dynamics between corporate retirement plans and institutional investors. This is especially because the retirement business theory has informed regulatory decisions, including decisions about the scope of disclosure obligations for certain institutional investors. And finally, I would say that while the retirement business theory focuses primarily on the relationship between mutual fund advisors and corporate managers, cast of characters are key players in this space is changing. Another consequence of the retirement plan fee litigation is that it has pushed plans to outsource ever more elements of plan administration to third-party professionals, and also to shift a growing percentage of 401k plan assets out of mutual funds and into lower-cost vehicles like collective investment trusts, which are functionally similar to mutual funds, but subject to a very different regulatory regime. So going forward, these developments should inform future work on the relationship between corporate retirement plans and institutional investors.
Our guest today has been Natalya Shnitser, Associate Professor of Law at Boston College. We've discussed her recent article, The 401k Conundrum in Corporate Law, which was recently published in the Harvard Business Law Review. I'll add a link to the article in the show notes for the episode. Natalya, thank you for joining the Business Scholarship Podcast.
It was my pleasure.
Thank you for listening to another episode of the Business Scholarship Podcast. If you like what you heard today, be sure to subscribe to the podcast on Apple, Spotify, or wherever you get your podcasts, rate the show, and let other people know about it too. If you have ideas for future episodes, let me know. My email address is andrew@andrewkjennings.com, and I look forward to hearing from you. Until the next time, I'm your host, Andrew Jennings.